Today was day 2 for gay marriage at the Supreme Court. Yesterday's arguments were over California's Proposition 8, which limited marriage to a man and a woman. But today's arguments were about the Federal Defense of Marriage Act, which, for the purposes of the federal government and its benefits, defines marriage as between a man and a woman. I want to go into some of the arguments that were made today, and we're glad to be joined by Ryan Anderson. He's a William E. Simon Fellow in Religion and a Free Society at the Heritage Foundation and co-author of What is Marriage? Man and Woman, a Defense. Glad to have you,
Thanks
Ryan.
for having me.
So here's the deal. Yesterday we talked about Prop 8, and we talked about several of the various justifications given for limiting marriage to a man and a woman. I can show you here that we put those up. This is a little mini version of my big yellow legal pad, but tradition, harm to the marriage, procreation. These were the reasons forwarded yesterday during the Prop 8 debate. Well, those reasons or justifications for limiting marriage to a man and a woman when it comes to Doma, well, we didn't really get to those. It was difficult to get to what those justifications might be because the justice kept asking one question over and over. Where is the federal power to define marriage? Justice Roberts, Justice Kennedy, over and over asked this question, and they got a little frustrated when they couldn't get their answers from the lawyers. Take a listen to Justice Roberts saying, "This is my question."
I understand that. That's your equal protection argument. It's not very responsive to my concern that I'm trying to get an answer to. You don't think federalism concerns come into play at all in this, right?
Well, I think I just want to clarify the equal protection question would be different in the other circumstance. That's a matter of
I know the equal
importance.
protection argument would be different.
He knows the equal protection argument. Please give him the source of power for the federal government to define marriage. And this was asked, Ryan, you'll remember, this was asked of all 3 of the lawyers who appeared before the court today. And they kept asking it over and over. And I want to play you one more clip because the greatest source of frustration, and if Doma fails, if it is ruled unconstitutional, it's going to fail at the feet of Justice Anthony Kennedy's frustration because he asked the question over and over, and he said, quit proceeding to equal protection. Answer the source of power for me. Listen to Anthony Kennedy.
Well, I think it is a Doma problem. The question is whether or not the federal government, under our federalism scheme, has the authority to regulate marriage.
Well, and it doesn't have the authority to regulate marriages as such, but that's not what Doma does. Doma defines a term as it appears in federal statutes. Many of those federal statutes provide benefits. Some of those federal statutes provide burdens. Some of those federal statutes provide disclosure obligations. It appears in lots of places.
So that was Paul Clement, lawyer for the House Republicans defending Doma. Ryan, Clement gave the best answers of the day to this. He usually does. He's a super lawyer. What is the source of federal power for Doma?
Yeah, the source of federal power for Doma is in each and every instance whenever the government has delegated authority to be making whatever policy in particular. So whether it's Social Security or immigration or national defense, that's where it gets its authority to make those policies. And if it's making policies in those domains that touch upon marriage, it then has to define what it means by the word marriage. It doesn't have to defer to how the 50 states define it, because we could have 50 different definitions of marriage in the 50 states. Some could be monogamous, some could be polyamorous, some could be polygamous, some could be restricting interracial marriage. If you go back historically, some did, right? So the federal government needs its own definition of marriage for federal purposes. When it's using the word marriage in the parts of its duly constituted authority.
That's the argument, Buck. It's a definitional power. We created laws. 1,100 federal laws that include the term marriage. We define what marriage means.
It seems like there's a clean way to break away from that, which is then just not have the federal government in the marriage business in any capacity. I think that Kennedy today took that line in a few places. It was very clear. And as somebody who's for limited government, it was interesting today. This was sort of a separate argument in a lot of context from what we saw yesterday. If you believe in limited government, you don't want the federal government to be intruding on these things. And traditionally, when you have a custody dispute, for example, when there's inter-family issues, that is a state issue. That has not been something that goes to the federal government, even if the parties are in different states. That's just been the way that it is. If somebody's in Oklahoma and somebody's in New York, they have a custody dispute, that doesn't go to federal court because there's always been sort of this understanding that the states are in charge of family relationships.
Pointed this out in relation to divorce. Do you have a federal definition of the word divorce? How do you deal with divorce between the many states?
Right. So I think for some aspects of marriage policy, those particulars do belong to the states. But there are other aspects that the federal government has to have a definition.
Social Security, for example.
Social Security, for immigration, national defense, and our armed forces. So I don't really think that your proposal is not even on the table. It's not something that's even plausible, and I don't see either side.
Meaning taking the federal government
out. We won't see the courts do that. Neither side of the disputants in this court case are suggesting that. So I don't really think that's even an option right now.
So here's my question about DOMA. Part of the impetus for passing DOMA back in 1996 was to protect states that don't recognize gay marriage from having to, should at this point, I think it was Hawaii that was about to legalize gay marriage. Yes. So what would happen if DOMA were struck down? Would states that don't recognize gay marriage be required to if a couple moved from Massachusetts to Arkansas, for example?
Not right now. So it's only Article 3 of DOMA that's being considered right now. And Article 3 was the part that defined marriage for federal purposes. It's the second part that said that a state doesn't have to recognize an out-of-state same-sex marriage. So that part would still stand. So that just protects each state's sovereignty to define marriage for state purposes.
I didn't want to conflate my own personal preference with actually what I think will happen here.
Well, yes,
Kennedy lines.
Yeah, he engages in a lot of interesting libertarian thought processes.
In a world in which Buck Sexton gets to make the laws, the federal government would not be making marriage laws.
Would the state stay in it for you?
I'm sorry?
Would the state stay in marriage for you?
I mean, I think that that's probably the most likely scenario. I think that, first of all, I think DOMA is going to get struck down. I think DOMA is done. So that's, if we're asking what's going to happen, and yeah, that would be my preference as a libertarian.
But I have to ask a question along those lines. Justice Sotomayor the other day raised an interesting question, which is sort of the limits of that fundamental right to marry. I'm curious what you think those limits actually are. And what you think she thinks they are from the way that she asked that question.
It's hard to tell what she thinks. But, I mean, I think we have to think about why is, so this gets to your libertarian question and to your question. Why is government in the marriage business in the first place? And it's not because it cares about my romantic life. And it's not because it cares about the romantic lives of consenting adults and what other sizes and shapes they take. It cares about children. And it cares about making sure that the act that unites a man and a woman endures for longer than just that night, so as to provide that child with the man and the woman, the mother and the father that created the child. And so, like, I care about limited government. I'm with you. I'm a fellow at the Heritage Foundation. But what we've seen is how, as the marriage culture collapsed, the government intruded itself to pick up the pieces. So during the 60s, 70s, and 80s, as marriage rates declined, divorce rates increased, cohabitation increased, out-of-wedlock childbearing increased. That's when the welfare state increased. That's when crime increased, prison populations increased, child poverty increased, social mobility decreased. So what the government can do is have an institution that holds up an ideal that a man and a woman, a husband and a wife, a mother and a father, right?
You're running into a place where you're saying, because I like something, even though I say I'm for limited government, in this case I like it, so I want the government to get big because this is good.
Not at all. This is an institution that places a limiting principle on the government. Because the government now recognizes the authority of a civil society institution, the natural family, to raise that child. It has an institution that's protecting the rights and the needs of that child, a civil society institution, rather than a big government program, a Head Start program or a midnight basketball program or a school lunch program.
You know, I like you painting the picture of the government as altruistic, and they might be in the business of caring about children. They're also in the business of caring about taxes. And whether the federal government or states get out of the marriage business, I want the tax code and marriage completely extracted from one another. And I don't know the logistics of how that shakes out, but I'm wondering, if DOMA is overturned, if Prop 8 is not upheld, do you think that solidifies the state's, the government's role in marriage, or does it diminish it? Because it's well, where is the government relevant at all?
Sure. So I have two thoughts in response to that. The first is for the tax code. At dispute today in the Doma case was the inheritance tax.
Right.
And it was a case of a same-sex estate tax. A lesbian couple, one partner passed away, the other partner was hit with an estate tax. You can ask yourself, what if it wouldn't have been a lesbian couple, but just two sisters living together who had shared a life together, one passed away, the other hit with the tax? Why would the lesbian couple deserve the tax break and not the sisters? They shouldn't. Both should get the tax break. So for the past 15 years...
Or no one should get a tax break.
For the past 15 years, Heritage has been suggesting that the death tax is a bad tax.
Yes. Right.
And we've been arguing for the repeal of the death tax.
Right.
This suggests that we can fix policy problems like this without redefining marriage.
Really quickly, just to talk about your definition of marriage and the purpose that it serves. I worked in the marriage licensing department for King County for 2 summers while I was in college. And I can tell you that that definition you gave collapsed a long time ago. We had couples who came in who didn't know each other's middle names, birthdays, clearly high, repeat customers, a woman getting her dancer's license one day and bringing in her old sugar daddy the next.
Right.
So when same-sex couples look at this, they say, we let heterosexuals who come into this institution for any number of reasons get married, but the state won't let us? How is that fair?
Well, so think about it this way. 40 years ago, we redefined marriage for the first time. with no-fault divorce. We introduced
Right.
no-fault divorce. And it used to be in common law, the 3 A's were grounds for divorce: abuse, abandonment, and adultery. The expectation was marriage was a permanent relationship, and you would sue for divorce because your spouse abused you, abandoned you, or committed adultery. The law now taught something new. Marriage could be gotten out of
Easily.
for any reason or no reason at all. And what we've seen over the past 40 years, divorce rates went from single digits to about 50%.
Which is what I'm suggesting, which is the purpose
So the
of
law
marriage has largely collapsed.
But why would we
because
want
of
to
that.
double down on that mistake? So introducing same-sex marriage, eliminating the expectation of male-female sexual complementarity, goes further in that direction. Ask yourself this question: how does a law teach that fathers are essential if it redefines marriage to say that fathers are optional? It's very hard for that. And President Obama himself has spoken very movingly about the importance of fathers, the centrality of fathers. But if we redefine marriage to say 2 men or 2 women, it's the same thing. Gender doesn't matter.
Ryan,
It's not a mother and a father.
We could all agree that fathers are not indispensable, that fathers are important, but it's not always a choice. And this is treating this as if you choose. Someone is choosing not to have a father. Someone is choosing for that father to leave. Someone is choosing to be gay. That doesn't happen. You can't always protect against
I think,
that.
wait, in the case of fathers, it is a choice, right? Fathers who abandon their children frequently make a choice to abandon their children.
As a child of that situation, and as someone who might enter into a marriage where that happens, that is not my choice. So why would I be penalized?
You shouldn't be penalized. What I'm trying to do is incentivize the child's chances of having his father commit to his mother, and then have the married mother and father take responsibility.
But that has not worked.
I just want to really.
Well, no, it used to work a lot better before we redefined marriage with no-fault divorce. Up until no-fault divorce, it worked really, really well. Almost every child was raised until maturity with their married mother and father until the introduction of no-fault divorce.
We are running out of time. It's a fascinating discussion.
We have to come back. No.
It's one that we ended up talking about policy and the government's role in influencing that policy. For the sake of the court today, it's going to rest on whether or not Anthony Kennedy thinks the federal government has a role in dictating that policy at the federal level. That'll be discussion. Ryan, thanks for being here.
Sure thing. Thanks for having me.
All right.